Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. When someone's tapped for jury duty, there are a lot of things they are told up front. They are told they have to answer the voir dire questions where the jury selection occurs. They have to answer those truthfully, and they have to answer them fully, and they have to volunteer information, and if they don't, that's a bad thing. And then after they're selected for a jury, they're told all kinds of other things. You have to pay attention. You have to, if you take notes, you have to surrender them at the end of the case. All kinds of instructions that the judges are going to give before you ever hear the first opening statement. One of the things that they're told is that the judge is the judge of the law and they are the judge of the facts. And that applies in both criminal and civil cases. But in the civil arena, you might be surprised to learn that there are a lot of things that are going to be kept from you as the juror. Now, some of those things probably should be kept from you. For example, the fact that the driver of the other motor vehicle that hit you has insurance is not relevant on the issue of negligence. In other words, because the state demands that we all carry insurance in order to drive our cars, you can't say that somebody having insurance means they were going to drive negligently. They had to have insurance or they couldn't have driven at all. So there's simply no logical connection between negligence and insurance. And the one leap you don't want jurors making is, what do we have to decide any of these facts for? Because they got insurance, they can pay some money. Let's give them some money. Because that sort of pretermits the whole issue of whether or not there was negligence. Simply put, it doesn't make any fact that bears on the issue of negligence any more or less likely by virtue of somebody carrying insurance. So the court will routinely not allow a jury to be told that a particular case involves a defendant that is being defended by an insurance company. But in truth, nearly all cases involving a motor vehicle accident involve an insurance company for the defendant. That is the entire purpose of mandating insurance coverage in order to drive. Now, probably if you thought about it, you'd recognize, given how much it costs to pay a lawyer by the hour, that guy who's driving the 1990 Ford F-150 and was involved in the accident and is accused of being negligent probably doesn't have the $300 an hour that his lawyer is billing. Somebody else is paying for that, and guess what? Yeah, it's the insurance company. Both sides have their little tricks to play about the insurance question. For example, the defense lawyer may put the witness on the stand, or after he testifies in the plaintiff's case in chief, the cross-examination might go something like this. And Mr. Jones, tell me what you do for a living. Well, I'm a carpenter. And where do you work? Well, I basically just pick up jobs as I can. I'm a union carpenter, so if there's a union job, I go do that union job, and then I move on to the next one. He may not be able to say, and how much money do you make at that? But the implication will be fairly clear that he is not making a lot of money as a carpenter or a bricklayer or a clerk at Dillard's, something like that. If someone has just barely over minimum wage job, they're going to get that evidence in some way. You know, where do you work? Well, I work at Chick-fil-A. Well, okay, you're definitely not pulling in 10 grand a month that way. The reason that they don't get into actually how much money people are making is because that also is irrelevant. But again, like I say, the implication will be that the defendant doesn't have a lot of money. So even though there's an insurance company with at least $50,000 in coverage in most states available to pay any amount of damages in the case, the defendant's lawyer is going to make it clear that his poor client doesn't have that kind of money. And of course, it's a giant red herring because he's not going to have to pay it anyway. It's going to be an insurance company in most cases. But what about the other side of the coin? What about that sneaky plaintiff's lawyer? What's he going to do? Well, if the insurance company involved is a mutual insurance company, like Farmers Mutual or State Farm Mutual, then in some states, that lawyer is going to be able to ask one question in voir dire. It'll only be one question, and there won't be any follow-up. Does anyone here have a relationship or investments in State Farm Mutual Insurance? Can I see a show of hands? And of course, if someone does, they'll take note of that, and they will probably be excused for cause because they would have a conflict of interest because they're going to be paying money against a mutual insurance company that they actually own a small piece of. That's what mutual insurance companies are. So they will get that information, and then, of course, everybody else is wondering why they're asking about that particular insurance company, and the really smart people will figure out, well, that's because that's who's paying for the defense in the case. So they can ask that question, but he can't follow up and say, oh, so you have State Farm Insurance. Do you think they should be held responsible to cover an accident if they insure somebody? You can't do that because that puts way too much emphasis on the insurance company. But of course, someone sitting out there on the juror, like I said, is probably going to figure out that there's an insurance company involved. But insurance isn't the only thing that's kept away from the jury. For example, if a person is walking up a flight of stairs and trips on a badly maintained step and breaks their leg, and the business immediately goes and repairs that step, the repair of the step cannot be admitted into evidence unless, for some reason, the defendant says, well, it was impractical to repair that step, or we couldn't repair that step because of where it was in the staircase. And of course, if they lie like that when they've already gotten it, repaired, they will then admit the evidence because you've denied that it was possible. And of course, it was possible. You fixed it. So that's really the only time that what are called subsequent remedial measures can be disclosed to the jury. Now, the public policy behind that is really a pretty good one. When people are hurt by something, we want to keep other people from getting hurt. So we don't disclose that to the jury because we want people to be able to repair things so that other people don't get hurt. Similarly, other similar incidents to the one that's being sued on may not always be admissible in all cases. In some product liability cases, other similar instances are admissible, particularly if a device or a product fails in the same way every time because of a defective part. The number of other similar instances can often be admitted. But if a person driving an Ford F-150 suddenly has his vehicle suddenly accelerate for no reason, and that's only happened 2 or 3 other times around the country, it would require a lot of specificity in order to get that admitted into evidence. While in some cases it is possible, like I said, to admit other similar instances, the law on this varies from jurisdiction to jurisdiction, and that's definitely, if you know of other similar instances in your case, you should talk to your lawyer about that and find out if it's something that may be valuable to them. Here's another thing that the court is not going to allow the plaintiff to tell you. That doctor on trial for medical negligence, he's been sued 7 times before. And in each one of those cases, he's committed a different error. But in 5 of those cases, his insurance company had to pay money. You're never going to find out about that as a juror. And that's because there's a strong public policy argument about that too. The idea that somebody was negligent on Monday is of no merit when you're trying to decide that they were negligent on Tuesday. Other instances of negligence simply are irrelevant for the purpose of determining whether someone was negligent at another time. So you're never going to be told about any of the other sort of negligent cases that he's been sued on. Now, we tend to think that where there's smoke, there's fire. But the fact that someone has been sued 7 times previously, you might think that means that they're not a very good doctor, but that's not usually the case. Many times doctors get sued because they take very difficult cases into the operating room or into the emergency room, sometimes even applying the most diligent methods and evidence-based medicine. People are still going to be, unfortunately, unable to be saved. It doesn't mean the doctor was negligent if he was sued for some other thing years previously, because in many cases, just being sued doesn't mean a thing. If someone recovered from him under similar facts where he's making a similar mistake to the one here, then sometimes you can get some of that in, but not usually. And again, it simply means in some cases that doctors take high-risk cases because of their specialty. That's especially true for obstetricians. Obstetricians tend to be sued a lot more than, for example, podiatrists. And that's because they're dealing with high-risk births and because that is such an emotional time. Sometimes people have to make very difficult choices between mother and baby. And sometimes those very difficult choices weigh on a person's conscience. And as a result, they tend to blame other people. I've seen it happen. That's not all cases, but it does happen. The inability to wrap one's head around what happened tends to cause people to start looking outside instead of looking inside. But of all the benign evidentiary rules that come up in a case involving personal injury, the most significant one, in my opinion, is that of the caps on non-economic damages. And non-economic damages are things like pain, suffering, disability, disfigurement, loss of enjoyment of life, and other things that you can't replace with a checkbook. In many states, these non-economic damages are capped at a certain level. They may not be capped in all negligence cases, but they may be capped in wrongful death cases, for example. And in many states, probably most states at this point, non-economic damages are capped in medical negligence lawsuits. Doctors seem to enjoy the ability to avoid paying for pain and suffering more than most other professionals. And if that sounds like it might be a violation of equal protection under the law, no court has so held. The really awful thing is that a jury might believe that Bobby Joe is entitled to $2 million for her pain and suffering. And if that case is tried in Kansas, the very most they're going to get for pain and suffering is $250,000. So a guy whose nail gun malfunctions and he shoots a nail through his left hand, he could get up to $250,000 from a jury. But the person who's paralyzed from the neck down has a much more impactful injury. He's capped at $250,000. And because the jury isn't told they might be capped, the damages might be capped for non-economic damages, they might very well issue an order, issue a verdict for $2 million to that paralyzed person, only to see that amount reduced to $250,000 10 minutes after they leave the courtroom. In the abstract, this sounds like a pretty good deal for insurance companies. They can plan better for how much money they are going to need to pay out if there's a cap on non-economic damages. But the problem is that if they know that the most they are ever going to have to pay is $250,000, they are never going to pay anywhere close to $250,000 to settle the case voluntarily. It makes it very difficult for a lawyer representing a client in a personal injury case to effectively represent his client when the court will ultimately take away what the jury may give in terms of non-economic damages. And again, because the jury doesn't know, they may give a lot only to see it thrown away by the judge. And by the way, the judge doesn't have any discretion in that matter. He can't decide, for example, that he really thinks Bobby Joe needs that $2 million because the law is very clear. The damages are capped. So when the judge says that he's the judge of the law and you're the judge of the facts, that's true only so far. If you find as a fact that the plaintiff is entitled to $6 million in non-economic damages, that's a fact you found, and it's certainly true in that case, but the plaintiff's never going to see that amount of money because the judge is the judge of the law says so, and the law also says no one can tell the jury about any of this. So, are those things you knew? Are those things you didn't know about our jury system and about our evidentiary rules? Let me know in the comments if you would. And of course, like, share, subscribe. If you have anything that you want to say privately, you can send it to me by email at the address above. If you have the opportunity today, take some time, do a kindness for someone. And then, when you have time, come on back, see me tomorrow down here at the beach. We'll talk about something else. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.